Hello everyone, welcome to the legal world of Unacademy. In this video, we are going to analyze the judgment in the case of K.S. Puttuswamy, wherein the constitutionality of Aadhar Act was challenged. So first of all, let me introduce myself. My name is Tanvi Singh and I am your Unacademy CLAT educator. I have pursued my LLB from Symbiosis Law School, Pune, and I have worked at various organizations. Other than that, I have been mentoring students for law exams since last 5 years. Also, if you want to attend my Unacademy classes, you can simply refer to the link provided in the description box, join my Telegram channel, and also if you need 10% discount on your Unacademy subscriptions, you can use my referral code TanviS10. So let's start our session. The name of the judgment here is Justice K.S. Puttuswamy and another versus Union of India and others. It was passed in the year 2018. The laws which were challenged here was Article 14, 19, 21, and Article 110 of Indian Constitution as violating the violated by the Aadhar Act. Here, the bench constituted of 5 judges. The case type was a civil writ petition. Number of opinions which were given at the end of the judgment were 3, in which dissenting opinion was given by Justice D.Y. Chandrachud. Case citation I have provided here, and aspect of privacy was informational privacy and dignity. So in this case, the Supreme Court upheld the constitutional validity of the Aadhar, Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act 2016. In short, we call it as Aadhar Act. And the judgment also declared that its legislative passage as a money bill was legal and valid, although Justice D.Y. Chandrachud dissented. The court was tasked with reviewing 27 different petitions, each challenging a distinct aspect of the Aadhar system. For instance, the court was required to decide whether it was legal to mandate the use of Aadhar to receive government subsidies given the possibility of exclusion of beneficiaries. The infringement of the fundamental right to privacy by the Aadhar Act was also contested in this case, with the petitioners arguing that the use of Aadhar to track and profile individuals violated the Constitution and constructed a surveillance state. The court held that using Aadhar for the purpose of welfare schemes was constitutional and upheld the mandatory linking of Aadhar with PAN cards. However, the mandatory linking of Aadhar to bank accounts, on the other hand, was declared unconstitutional, as the provision did not meet the test of proportionality and thus violated the right to privacy. In its majority judgment, the court also struck down Section 57 of the Aadhar Act, holding that private companies could not require citizens to provide their Aadhar numbers for the provision of services. The facts of the case are, in 2009, the Indian government devised the Aadhar project as a universal identification system to better track disbursement of services provided by it. Now, the Aadhar project entailed the collection of biometric information of individuals to be used for identification and authentication of service delivery, and was initially begun by the way of an executive order in 2009. Now, the Aadhar project received statutory sanction by the enactment of Aadhar Act in 2016. However, the Aadhar project attracted public scrutiny, and eventually both administrative action as well as the Aadhar Act were challenged before the Supreme Court for violating the Constitution, including the right to privacy. The first writ petition was filed in 2012, but doubts were raised as to the existence of right to privacy as a fundamental right, which led to the constitution of a 9-judge bench in the case of K.S. Puttuswamy and another versus Union of India. This is referred to as Puttuswamy 1 case. So Puttuswamy 1 case was an earlier case before the Aadhar judgment. Puttuswamy 1 case basically affirmed that the right to privacy is a fundamental right of the citizens of India. Following which, the court posted the matter for final hearing in 2018 before a 5-judge constitutional bench. Now, this judgment is known as the Puttuswamy 2 judgment. So there were primarily 5 issues which were there. So whether the Aadhar project created or had the tendency to create a surveillance state and was constitutional on this ground. This was the first issue. Second, whether the Aadhar Act and Section 139AA of the Income Tax Act violated the right to privacy and were unconstitutional on this ground. Thirdly, whether children could be brought within the sweep of Section 7 and 8 of the Aadhar Act. Fourthly, whether the Aadhar Act could be passed as a money bill within the meaning of Article 110 of the Constitution. And lastly, whether other sections of Aadhar Act were unconstitutional. Now let's have a look at the arguments of both the sides. So from the sides of the petitioner, the argument pertained to privacy, surveillance, data protection, consent, and the legislative process. It was argued that the information collection for Aadhar was mishandled since the Unique Identification Authority of India had employed several third parties for the work. Further, they argued that the project was laying the groundwork for a surveillance state. With regard to consent, they argued that by making Aadhar compulsory for basic services and daily requirements like banking, SIM cards, phone connections, people were not practically in a position to withhold consent, and that the idea of consent was therefore illusionary in nature under the Act. The petitioners also argued that by making biometric authentication a prerequisite for getting subsidies, exclusion from welfare benefits had increased. The petitioners submitted that the objective of creating a single pervasive identification over time was illegal and thus rendered Aadhar Act violative of Article 14. Finally, the legislative passage of the Aadhar Act as a money bill was questioned by the petitioners. And it was argued that by passing the Rajya Sabha was unlawful and therefore the act was inherently invalid due to the problematic legal process behind its enactment. The arguments of the respondent were that the information gathered for the Aadhar project was non-invasive and non-intrusive identity information of the people of India. Now, it was argued that the Aadhar scheme and the manner in which it operated excluded every possibility of data profiling, and therefore the question of state surveillance would not arise. It was also argued by the respondents that identity information data resided in the Central Identities Data Repository (CIDR), which was not in the control of government or the police. The respondents further argued that enough safeguards were in place in the Aadhar Act to avoid any data breaches. The respondents submitted that the tests laid down in Puttuswamy 1 had been satisfied and hence the Aadhar Act was not unconstitutional. Now, the Supreme Court, looking at the various facts, decided that the constitutional validity of Aadhar Act, its passage as a money bill, and the use of compulsory Aadhar-based identification for those state welfare schemes, the expenditure of which was borne out of the Consolidated Fund of India, was upheld here. On the question of whether the project created or had the tendency to create a surveillance state, the court said that neither the structure of Aadhar nor the provisions under the Act created a surveillance state. Also, taking from the arguments presented by the UIDAI, the court said that only minimal biometric data was collected during the process. The UIDAI was purpose blind as it did not gather the purpose, location, or other information related to the transaction. The collated data was isolated. The merging of such data which was obtained was banned. The process of authentication was shielded from the internet, and that ample security measures were undertaken, and the use of only registered devices was mandated for requests related to authentication. Now, therefore, the court held that it was extremely difficult to profile individuals based on their biometric and demographic information stored in CIDR. Certain provisions relating to data protection were strengthened by the court, which ordered that authentication records, the records which were being kept through the biometric were not to be stored for a period longer than 6 months, as opposed to the permitted 5 years under the Act. So this was held as unconstitutional. 5 years जो आपके section में दिया हुआ था under the Aadhar Act, that for 5 years the government can store information that were collected. It was held that it should not be stored for a period longer than 6 months. Now, on the question, next issue, which was resolved by the Supreme Court, on the question of whether the Act violated the right to privacy. So, court referred to the earlier decision in the Puttuswamy 1 case, 2017 decision, where privacy was declared to be a fundamental right, and stated that any invasion of the right to be justifiable must meet the threefold requirement of, first of all, legality, which postulates the existence of the law. Need, secondly, the need defined in terms of legitimate state interest, and proportionality, which ensures a rational nexus between the object and the means adopted. So, in the opinion of the court, the very existence of the Aadhar Act, coupled with the aim of delivery of welfare benefits, passed the first two prongs of the test, the legality and the need. The court stated that the third requirement of proportionality had also been met, as the purpose of Aadhar Act was to accurately identify the beneficiaries of state welfare schemes, and that it achieved the balancing of two fundamental rights, with privacy on one hand and the right to food, shelter, employment on the other. While Section 139, next issue was Section 139A of the IT Act, which provided for mandatory Aadhar PAN linkage, was upheld. The mandatory linkage of Aadhar with bank accounts was held to not satisfy the test of proportionality and was struck down. Similarly, the mandatory linkage with mobile numbers was not upheld. Next issue, on the question of whether children could be brought within the sweep of Section 7 and 8 of the Aadhar Act, the Supreme Court held that for a child's enrollment into the Aadhar program, parental consent was mandatory, and that such enrollees were entitled to opt out on attaining the age of majority. On the question of whether the Aadhar Act could be passed as a money bill within the meaning of Article 110 of the Constitution, the court stated that considering the fact that the aim of the Act was to create a unique identification of each and every individual, so that deserving beneficiaries were able to access subsidies or services, the expenditure of which was drawn from the Consolidated Fund of India, therefore the Aadhar Act was validly passed as a money bill. However, certain sections of the Aadhar Act were struck down as unconstitutional. First of all, Section 57, which allowed the use of Aadhar by private companies, was one such provision. The judgment stated that the term any purpose in Section 57 was vulnerable to misuse, and that permitting any company or person to use Aadhar for authentication based on a contract would allow exploitation of private data and thus violative of the right to privacy. Henceforth, Section 57 of the Aadhar Act was struck down as unconstitutional. Similarly, Section 47 of the Aadhar Act, which provided that only UIDAI could file a complaint in the case of violation of the Act, was struck down, and it was directed that the provision must be amended to include any individual or victim whose right has been violated. Now, Regulation 27, that provided for storage of data for a period of 5 years, was struck down, and it was held that retention of information of an individual should be for a period longer than 6 months, was not permissible. Earlier it was 5 years. आपके एक्ट में रेगुलेशन में लिखा था कि 5 years of period of information retention should be there. However, it was held that 6 महीने से ज्यादा आप नहीं रखना है. Now, Justice D.Y. Chandrachud, in his dissenting opinion, made several notable points with regard to privacy violations by the Aadhar project and Aadhar Act. First of all, he held that legislative passage of Aadhar Act as a money bill was unconstitutional. Secondly, he also noted that adequate norms needed to be laid down for each step, from the collection to retention of biometric data based on informed consent, along with specifying the time period for retention, Individuals must be given the right to access, correct, and delete data, and an opt out option should be necessarily provided. Thirdly, he also pointed out that the Aadhaar Act was benefit of these privacy safeguards. He also raised questions on the independence and accountability of UIDAI. Justice Chandrachud also stated that while the requirement of a legitimate state aim was met, the Aadhaar Act did not meet the requirements of necessity and proportionality, as per the Puttaswamy 1 judgment, wherein three tests were provided in order to ensure that the particular act is violating your right to privacy or not. So, Justice Chandrachud was of the view that act did not meet the requirements of necessity and proportionality. He added that the legitimate aim of the state could be fulfilled by adopting less intrusive measures as opposed to the mandatory enforcement of the Aadhaar scheme as the sole repository of identification. In his opinion, the state had failed to satisfy the court that the targeted delivery of subsidies, which bolstered the right to life, entailed a necessary sacrifice of the right to individual autonomy, data protection, and dignity when both these rights were protected by the Constitution. He further held that Aadhaar violated the principles of informational privacy, informational self determination, and data protection. He reiterated the point that Aadhaar bore the risk of creating a surveillance state and stressed the additional risk of commercial profiling of individuals and potential swaying of elections. He also held that in absence of an independent regulatory and monetary framework which provided robust safeguards for data protection, the Aadhaar Act was violative of Article 14. Finally, Justice D.Y. Chandrachud stated that Aadhaar Act was overly broad and not effectively limited. However, the Supreme Court, in a majority of 4:1, wherein Justice Chandrachud was the gave the dissenting opinion, the bench upheld the Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefits and Services Act 2016 as constitutional. However, it struck down the individual sections of the act as unconstitutional, like I have told you about in this video. So thank you so much, guys. That's it for the day, and I hope that you found this useful. Thank you.